Right. In 24 CR 2449, you were J.W. Marshall, present with your attorney, Mr. Burbank, and the state's attorney. Mr. Burbank is your attorney, correct? You see, but he's filed a bunch of motions on your behalf. And these things that you're filing, court doesn't accept. You have a lawyer. This is what's called hybrid representation, which is disallowed under the law. You got to either trust your lawyer, you run this by him, then you do what needs to be done. But there's not things I'm going to consider because he's the lawyer of record. You have a right to be heard, of course, but you can't have two lawyers unless you pay for them. You and him can't do it at the same time. He's been assigned. I don't know. Did you hire him? Okay, you were appointed. You want to represent yourself. Anytime you want to do that, let me know, and that would be a choice. It's always been a bad decision, but some people are insistent, and it never works out well for the defendant. That's been our experience in this room with 18 and a half years and 600 jury trials. We can figure out what's the right way and what's the wrong way. We've seen it so many times. But this is, when you send this, the court's not going to receive it because you have a lawyer and he's the one responsible for filing the motions and representing you. So you don't want to get into a spot of where, well, you're going to be doing it and he's gone. See you. He's a wise man. You got to trust him. Run it by him. He knows how to do it and what is the best way to represent a defendant. Okay? All right.
One of the motions that he did file was for possible harm reduction. I did file a motion that I signed off for. Basis, if I may just
yes, sir.
briefly, is that prior to the charge of murder being filed against him, he was out of law. There are other cases in his file that he was taken care of. He was out of he was compliant with all those regulations showing up to court, abiding by the rules and conditions. When this new office they, of course, put a new bond based on murder charge. And he's been in custody since then. He's asking for consideration of us producing those bond down.
Well, this, in summary, states the bond is presently at $1 million, and you are asking on behalf of the defendant that the bond be reduced to an amount that the court determines is reasonable. I know what the background is and why this was done this way, but does the state have anything to add here?
Yes, Your Honor. The state obviously we're objecting bond reduction. The defendant has 4 prior felony convictions, so he is a habitual offender. At least 2 of those are in sequence. Also, the nature of this crime, it's alleged that both the defendant and Jamal McKean, another co-defendant, gunned down the victim in this case, and it is on video. You can see 2 individuals gunning an unarmed victim down and shooting him multiple times, both of the individuals doing it.
Anything you want to answer? You need to go? Okay. All right. Okay. A couple of decisions the court's going to make. Number one, this court is going to deny the motion for bond reduction. I've reviewed the criminal history. I have reviewed the circumstances of the offense. Those are the key determiners in determining what a bond is under law. Number one, murder. Yeah, that is the most aggravated and violent crime, unless it's multiple. Number two, you, according to this indictment, have at least 4 prior felony convictions dating back 24 years. and not the least of which is a conviction of robbery in 2007, which is a violent crime. The others are, it looks like, illegal possessions of controlled substances, which are felonies. So this, if true, constitutes a habitual offender. Your punishment range is no less than 25, no more than life years in prison. And that's as serious as it gets. So this is number one, serious felony of murder, most serious felony. It's the use of a firearm. Somebody is killed. It's a violent crime. You have multiple felony convictions, including another violent crime. And in reviewing the probable cause affidavit, this court finds that $1 million in bond is most reasonable under the circumstances of the case and your written criminal history. So we're going to set this for trial.
We're going to ask them to be set as soon as possible.
All right, what do y'all need to do to get ready? Because I'm going to try to accelerate this, please.
Your Honor, won't take much. I think the co-defendant is currently set for October. So
Anything can happen in the case.
I think we'd prefer to go on the co-defendant first in October. I think that's when we're set to go on that one. Get everything ready. Mr. Marshall was arrested after this, after we received the additional information.
Lacey, I need to set right after the co-defendant's case.
Yes, sir.
Okay, we'll get you.
And we're off. The judge wastes no time diving straight into legal housekeeping. But watch closely, because this defendant's confusion over who's really in charge sets the tone for the entire hearing. Hybrid representation, that's courtroom code, for this is about to get messy.
File real quick and then I'll put them in.
Anything else on this?
No,
Thank you. That is all. Yes.
Again, for now.
Yes, sir. You are Kevin Wayne Turner. In summary, sir, this indictment in 24 CR 1711 states that on or about June 13th, 2024, in Jefferson County, Texas, you committed the third-degree felony of evading arrest and detention with a motor vehicle. Do you understand that you were charged with this, sir? If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? Yes, sir. The agreement's been reached for you to be pleading guilty, placed under parole or unadjudicated probation, and be up to 10 years in length.
Yeah.
There is no fine. You do well, you can start it at 130. 3 seconds. Is that your understanding of the agreement? Yes. If I follow this, you have no right of appeal. Do you understand? Yes. Have you pleaded this guilty or not guilty? Guilty. And pleading guilty voluntarily is on your own free will, because you are. Somebody else? Did you sign that document, State Exhibit 1? Yes. Did you understand it? Discuss it with Mr. Renning? Are the contents all true and correct? Yes. State Exhibit 1 tendered into evidence, without objection admitted. Among other things, the state you were mentally competent to enter your guilty plea, explaining the voluntarily. Yes, sir. Hold on, everybody. I can't hear. Everybody, thank you. You were mentally competent to enter your guilty plea. There is enough evidence from State Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. You are giving your rights to a jury trial and the rights to the apparent confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer, officer, so help you God. State Exhibit 1 is part of the record for all purposes. Pre-sentence report as well? Yes, please, John. Okay. Let me ask you a couple of things. Criminal history on defendant?
No, sir, I don't know.
This is an agreement for 10 years. Is you asking for less?
Yes, Your Honor, I am.
What state say?
I don't have a problem with that, Judge. What's based on
That's 5. 5. Because once again, it's a term. You can throw it into a term. Got to be longer than a misdemeanor, which is 2 years. Okay. Fine. If nothing further, I'm going to find, sir, you have pleaded guilty voluntarily. You are mentally competent, and you say you understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting the guilty plea to State Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to defer any findings so long as you follow the terms and conditions of probation, which will be for 5 years and length. The probation officer will go over these with you. These are normal and customary. Essentially, most of these, if not all of them, are conditions I have to follow every day. There is no fine here. There is, though, you're going to be.
Notice that subtle warning from the judge. He's been through 600 jury trials, and he's basically saying, I've seen this movie before. Defendants who represent themselves almost always regret it. Ever wonder why? Because emotion rarely beats experience in a courtroom.
Order to take an defensive driving course as a condition of probation. And people kind of laugh about that one, but there are two things. Number one, it helps you kind of remember in your mind this is a 4,000-pound missile you're driving around, and it can do a lot of tissue damage. It's something else for people. So we've got to be very careful in the way we operate motor vehicles on places. Plus, you're going to get a reduction in your insurance by doing this. So it's a win for the probation. Please meet with the probation office. Again, now thank you, Judge. All right, we now call 23 CR 1490, the state of Texas versus Joshua Booker, who is present with his attorney, Mr. Wilkerson, and the state's attorney. Does the defendant waive a formal reading of this indictment here? Can we proceed in summary?
Yes, Your Honor.
All right. In summary, Mr. Booker, this indictment alleges in paragraph 1 that on or about December 1st, 2021, in Jefferson County, Texas, you committed the first-degree felony of aggravated sexual assault of a child. Do you understand what you were charged with here? Because the child was younger than 14 years of age, this becomes it's referred to as a super aggravated first-degree felony, which means the punishment range is enhanced from not less than 5 to not less than 15 years imprisonment, up to 99 years imprisonment or life imprisonment. Do you understand the punishment range applicable? And I guess as well, a fine up to $10,000 could be assessed. That's not going to be of consequence in this case, correct? That's correct. You understand what you're facing here, sir? Yes, the answer is that's nice, lady. The agreement's been reached where you would be pleading guilty, sentenced 45 years imprisonment. Is that your understanding of the agreement? If I follow this agreement, sir, you have no right of appeal of your case. Do you understand? Are you pleaded this guilty or not guilty, sir? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Show you what's marked as State's Exhibit 1. Sign that document voluntarily, understand it, discuss it with your attorney, or the contents true and correct. State's Exhibit 1 tendered into evidence without objection admitted. States you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this true state, so help you God. Is that true? State Exhibit 1 is made a part of the record for all purposes. Sentence report is waived.
Yes, Your Honor.
Sir, I'm going to follow this agreement. If nothing further, I'm going to find you, Joshua Booker, pleading guilty to this aggravated sexual assault of a child as indicted in 23 CR 1490. You were doing this voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here. Finds you guilty beyond a reasonable doubt. They now find you guilty beyond a reasonable doubt of this offense. I am following this agreement. You are hereby sentenced to confine in the institutional division of the Texas Department of Criminal Justice to serve a term of 45 years. Do you understand what has happened today, sir? And you'll be given credit for all time you have served in connection with this offense. To now. How old are you?
18.
You're 18. Right. In 24 CR 319, here's the indictment that the grand jury handed us. It alleges that on or about November 2nd, 2024, in Jefferson County, Texas, you committed the first-degree felony of robbery with the use or exhibition of a firearm. Do you understand what you were charged with? If convicted of this, you are looking at even 18-year-olds, 17-year-olds. You are looking at, if convicted, no less than 5 nor more than 99 years confinement in prison or life in prison, and a fine up to $10,000 can be assessed. Do you understand what the statute says? There are. What's the offer this minute?
The offer was been 12 years, capped on small amount of no felonies. That's why I felt like
Yes. It's called a cap, and a lot of people don't understand what that means. These are options for the court to decide. If it's 12 years in a cap, this is the cap means that's the worst.
Whoa, the state just dropped a bombshell. They've got video evidence of a shooting. That's not just damaging, it's devastating. Once a jury hears on video, the defense strategy instantly shifts from denial to damage control.
That can happen. But the court has the discretion of, in this case, no less than 5, no more than 12 years, not life. So not anything more than 12. Also, the court has the option of placing you on a form of probation which is called deferred or unadjudicated probation, where you would not be found guilty. You can't get regular probation, which is the other form of probation, from a judge when you have a firearm used in the commission of deadly weapons, used in the commission of crime. The statute does not allow that. Now, a jury could consider it if you are eligible, but just eligibility for probation does not grant it. That would be a form of probation where you are found guilty the rest of your life of a felony, and you just would have a limitation on how much prison, if any, you would spend. But even in regular probations, the court says you were granted, if you were granted probation, and they could also sentence you up to life in prison. There would be no cap for a jury. The jury has the full discretion of the full statutory limits. Conditions of probation are set by the court, and I would monitor the difference in regular probation. If you failed, your probation could be revoked. You could be sentenced up to 10 years in prison. Not life, but up to 10 years. In deferred or unadjudicated probation, you're not found guilty, so you don't have a record so long as you follow the terms and conditions of probation. And you've been sitting here, these terms and conditions of probation are just the same thing I have to follow. I mean, the first one says don't commit a crime. That's me. Can you imagine what would happen to me if I committed a crime? I'd lose everything. And then other things that are good about curfews, you're not out and about nights where people get in trouble. It's to help you fix the mess and to have good habits and get through probation without being revoked. You failed, your probation could be revoked and deferred or unadjudicated probation that this court has the option for, and not regular, but the court can be deferred. And then you can be found guilty and sentenced up to the full range of punishment. And people have to make decisions when this occurs, because it keeps you from having a conviction which follows you the rest of your life. Even regular probation in front of a jury follows you the rest of your life. Closes doors of opportunity. People have to think about this option of a cap, because number one, there's a limit to what the court would assess. I can't go above if it were seen, if you agreed for me to do it. But also, I have the option of placing you on deferred or unadjudicated probation, which is really what everybody charged with crimes in this court really wants. But the decision.
There it is, the $1 million decision. When a judge refuses to reduce bond, it means one thing. They believe the defendant is a major risk to the community. Habitual offender status plus violent history equals zero leniency. Do you think that's fair? Or should past mistakes ever stop someone from a second chance?
You're a grown up now. And the decision is going to be left with you. It's your life. You have to decide what direction. Now, you're presumed innocent unless you're found guilty. That's a presumption. Right now, if somebody asks you don't want to say you're guilty, you're presumed innocent. But most cases in this court are disposed of without jury trial. You see what we do. We get pleas. Most 90-something% of the cases are disposed of by agreements where people generally feel as though they can handle the probation and they can take it and they can move on with their life. We have a 92% success rate in probation. The national average is about 70 or 75. We take care of our probationers. We're proud of them because we're like one of the best in spot activity. So getting people to make a mistake, fix their mistake, and do good. You got to think of all of this. But it's your life. And all we can do is give you information so you can make an informed choice. This is important. I'm going to give you a week to think about it. All right? Do you live with your parents? Do you trust them? Talk it over with them and see what they have to say. But we'll be back. You got a week to decide which direction you want to head in. You have a right to a jury trial. But he'll tell you what the success rate is for jury trial here for defendants. So you got to think long and hard about this. But I'm not trying to tell you. So, people get acquitted here too. You get acquitted. More often than not, they're not by juries. And juries do good things. They're wise people. They listen. They think. They're very considerate of their jobs, but they're also concerned about the criminality that this is our county, and we want this to be the safest county we can make. And people make mistakes. It's how you deal with your mistake is the real test of whether your character is good. So trust your parents. Good. They're good people. You talk it over with them, and yeah. And I'm sure, like me being a parent, I love my children. I wouldn't want anything bad to happen to my children, but I would want them to make a wise choice because this is life deciding one way or the other. And that is what I'm going to tell you. Please heed that advice, and we'll have you back in a week, okay? And then you make a decision. Okay. Get a resetting, son. Thank you.